suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is here in the studio and he's ready and willing to help. 1300 222 774. I've got 2 lines free. That never happens. David Whiting, what's going on?
You didn't spruik early enough.
Didn't spruik. Listen to him and the radio talkback lingo. Spruik. Aren't you good?
Forward promote, I think, is the technical
Oh, he's just seen me and raised me. Okay, mate, you want to see? I think you should.
No, definitely
Come
not.
on, over here. Hang on, I've got something to read to you before we start. Where is it? All right. Dear VT, I have a problem. That's where you can step in. No matter what else we are supposed to be doing at 10 a.m. on a Tuesday, my wife goes back to bed and listens to David Whiting, hanging on his every word. We have nice neighbours with good fences and we obey all road rules. So many of the problems of your callers don't relate directly to us. I am now imagining that she must be waiting for a family law issue to be discussed. Am I paranoid? Is she secretly dreaming of running away with David? You're a woman of the world, so what do you think? By the way, we both love the segment. Do you think she's lawing up here and just getting a few skills in the tool bag in case she plans to sue her husband and run away with, I don't know, you?
Just want something to talk about at the next cocktail party. That's what it is.
Don't you? I love the image of going back to bed. That is it's a great image. Hat up, got your coffee, done a bit of gardening. Nope, back to bed with David. There's the name of a segment.
Back to bed with David. Oh, your life can be, that would be one of the more disappointing segments, I think.
Let's move on.
Before we do, we had a caller from last week. Melissa rang in relation to, she lived in an old-style block of units and created under the Strata Titles Act, which was between 67 and about 85. And she wants to buy a unit that's marked as an accessory unit. And the question is, can she? She wants to buy a car park from someone else in the development.
Rightio.
And back then they had restricted units and accessory units. And you couldn't sell the restricted units, which were the ones that people lived in, without an accessory unit, which were the car parks.
Right.
All right. Now, can she do what she wants to do? Yes, she can. But the better thing to do would be to make an application to council. So it's an application for a planning permit to remove the restriction. So Subdivision Act sections 83 and 83A, you can move the restriction on accessory units and you can apply to remove the restriction on restricted units. So that's where I would go and both of you, the one who wants to sell and the one who wants to buy, could share the cost.
Okay, there you go.
Yep.
Easily solved. All the lines are taken, so let's get to some of your calls. Cecilia in the CBD. Hi, what's going on? Good morning.
Hi, good morning. Thank you for taking my call. My question is, I'm asking for my friend, and then my friend, as she has a unit which she has rent out to a lady last year in June. At that time, they didn't sign any contract because, and then the only agreement is if the lady wants to move out, she's going to give a month notice. So as if my friend wants the unit back, she will give the lady a month notice.
Cecilia, your friend has what's called a periodic tenancy under the Residential Tenancies Act. And a month's notice is not adequate for a periodic tenancy.
Yes.
And it depends upon what your friend wants to do with it as to what the notice period is. And it might be as little as 2 months and as much as 4 months.
So actually, last year in November, then my friend wanted it back. And then she asked her to move in February, thinking giving her 4 months is enough to move. At that time, she said, no, she's not moving out. So after negotiations, so my friend agreed to let her stay in until June. So in April this year, so my friend reminded her she has to move out in June. And then she said, no, she's not moving out.
Celia,
so after,
there is a process contained in the Residential Tenancies Act. And if you don't follow the process in the legislation, the notice that your friend gives her tenant is not valid.
So what's the process you have to follow?
there's a particular series of provisions, and they depend upon, am I going to move back in? Am I going to sell it?
Yes.
Or do I just want you to go? And if I just want you to go, it's 120 days. And there's a series
No, she wants to move back in.
Well,
My friend
but
wants
then-
to move back in.
Yeah, then you need to look at Consumer Affairs, and there's a special process that you need to quote particular segments of the legislation and provide all of the information required. And if you don't do it properly, it's as if you've never served the notice. Now, if you serve the notice properly and the time expires and the tenant has not gone, then you make an application at VCAT for possession. Right?
So,
And if
is there any option apart from going through VCAT, because she has done all this? She has looked up the
hang
consumer
on.
affairs. No,
But if she's done it properly, no, the answer would be the process for getting a tenant to move at the end of a tenancy agreement is the process at VCAT. There's no separate one for your friend. It's
So
the
just
same for everybody.
So just giving the notice in November to leave in February
A problem,
is still
Virginia, is
not enough?
we don't know whether the notice was given in accordance with the legislation.
And how is that notice given in accordance?
Well, you've got to state which section in the Residential Tenancies Act you're giving the notice in accordance with.
Because I'm moving back in, because I'm selling it, or whatever it might
Yes,
be.
yep.
I see. Okay. Well, they're the questions for your friends to answer, Cecilia. I hope that's clear enough for you to go on with, but you'll have to clarify the way the notice was given, what was specifically stated,
In the notice,
In
yes.
the notice?
And what the period was in the notice.
and what the period was in the notice. And then, if not, the clock might start again.
Yes, it could
Okay.
well do.
All right. Thanks for calling in. Good luck with that. Gay in Mornington. Hi, Gay. What's happening there?
Oh, hi, Virginia. Hi, David. Thanks for taking my call. I had a plumber come last week to my property in Mornington because I had a blocked drain, kitchen sink, and upon inspection, he's found, I've only had the property for about a year. Upon inspection, found that, number one, the drain doesn't really go anywhere from the kitchen sink except to under the deck, where there's no outlet.
what you're telling me is the kitchen sink doesn't go to the sewer.
No.
Wow.
And also...
So how old is the house, Gay?
Well, the house, there's been owner-builder renovations done, which I've written to council and got all the plans and the permits, and I've contacted the person who did the permits. But subsequent to that, they've inspected the back of the house.
Gay,
Yep.
when a property is sold by an owner-builder, there is a...
No, there was another person in between that.
I understand, but when the property, presumably the property was worked on by the person who got an owner-builder report, sold it to the person to you, who then sold it to you. You
Yes,
do have
correct.
the owner-builder report effectively says we've identified these defects. There's no insurance in respect of them, but you do get the full 10-year owner-builder report in respect of the rest of the work.
Right.
Right, so you do
So-
have a claim on that policy.
Right, and and then subsequently they found that all the plumbing at the back for the back bathroom is totally not suitable, and we're not able to use the main bathroom because they're worried it's going to collapse, and it needs to be redone.
Gay,
So I'm getting,
Gay, I haven't seen the defects report. My view is that you've probably got a claim on the insurance policy, but you're also likely to have a claim on their owner-builder.
All right.
All right? So you've got the right to bring an action against the owner-builder for all of the work which wasn't done properly.
And is that clear how you bring that action?
It would be depending on the cost of repairs in the Magistrates Court or the County Court.
Okay, in those
Yep.
courts. All right.
Yes.
Good luck. Hope that helps, Gay. Good morning to you. Peter in Ocean Grove. Hi, Peter. What's going on?
Peter from Ocean Grove. Yeah, thanks for taking the call.
Go ahead.
About 18 months ago, I moved into a lifestyle community village in Ocean Grove, and I had a perfectly valid will. But after I did some checks, I found out that the will is null and void when you move into a lifestyle community. All the will is just doesn't matter.
What?
No, Peter, no. Your will, your will continue to work, right? Except that there are some elements that may not work. So let's say, for example, that your will says, and on my death I give the unit to Virginia, right? Well, what happens is that your contract with the village says they have the right to take it back. So the gift that you've made in your will won't work because of something else that you did while you were alive. So your will still works to the extent that the asset is available to give for that to happen.
Okay, so what's in my will where I bequeath stuff to my children? My wife passed away about 12 years ago, and I've got a partner now.
Yes.
My concern was that it would all go to her and my children wouldn't get anything out of it.
So have you made a new will since you went into this new relationship, Peter?
I have.
And then my view, then that is the will that you've got. That's the will that will work, subject to there being the possibility of a challenge against the will if you haven't adequately provided for your partner.
Oh, no, all that's taken care of. But
Good.
It's just,
Then the will will work. So I mean, let's say that the unit in the Lifestyle Village is in your name.
Yep.
If it's in your name, then the Lifestyle Village operator has rights in respect of the unit, and that may mean that you can't pass the unit to your partner. If the unit was in both names, then you would both share the rights in relation to that unit till the second of you died.
Right. Well, that's what's happened. It's in both of their names, otherwise...
But I've got to tell you, you both haven't died yet.
Thank you for pointing that out.
Okay, no problem. I know you've been waiting for a while, Peter, but okay, yep.
All right. Thank you for that.
Thank
Okay,
you. I
thank
hope
you.
that's clear. Good on you, Peter. Thanks for calling in. Neil in Ballarat. What's happening, Neil?
Thanks for taking my call. I've got a question involving a tree. A very large tree from a neighbour's vacant land has fallen over our backyard, and the tree itself is about 30-odd metres long, probably about 8 or 10 cubic metres worth of wood.
Yes.
The neighbour is claiming ownership of the wood and wants to have the wood. We want to keep it because it's very good for timber and firewood for burning.
Your neighbour owns the tree, Neil.
He owns what's
Yes,
on the
but-
neighbour's land, yes.
No. The tree that was growing on your neighbour's property and is currently lying across your backyard belongs to the neighbour.
Okay. So we can't use the timber, or...
No, it's someone else's property that happens to be... It's like saying someone parked a car in my driveway, I now own the car. It doesn't work that way.
Hang on, but I've got a question. But that tree that's coming over from the neighbour and over my fence line, I can cut that down. I can cut that branch that's going over
But it doesn't mean you own the branch.
I have to throw the branch back.
You don't have to, but it technically
Well, do I
belongs
have to
to
or
the
not have
neighbour.
to throw it back?
It belongs to the neighbour.
So
No.
the
We have a whole series of rights, Virginia, that from time to time we choose not to exercise. So, if I was trimming the neighbour's trees in my backyard, I would just get rid of the trimmed branches. But if there's 8 or 10 cubic metres of usable timber that's across my backyard, my neighbour may say, really like that back.
have you asked the neighbour, Neil?
They've just said that they want the wood. We have not gone further than that. My problem is that it's also an insurance claim. We'll be paying several $1,000s, or we'll be paying another items of damage as well.
Yes.
It's a massive tree to cut up. You actually need a professional. I'm good with a chainsaw, but you need a professional person to do it.
Yes.
So our insurance will be paying for all that. Yet he can.
No, why? Why would... No, I'm saying I would be making your neighbour remove the tree. It's your neighbour's tree.
Okay, so if he refuses to remove it?
Well, I'm trying to do the courts out of business regularly here, Neil. But you would have the right to obtain a mandatory injunction that the tree be removed.
Okay.
Yeah, I mean, a dirty big tree's just fallen across your backyard. It's their problem.
Yes.
I've just wondered
something
if they didn't want the wood, you could salvage it.
Yeah, or a car runs into your front fence and it won't remove the car. It makes no sense.
Okay,
It's your
but
neighbour's tree. And your neighbour has to remove it. And if necessary, you have to sue him for it. Or you might make a claim on your insurer and then let them deal with the issue.
And the neighbour has to pay for the broken fence, I imagine, if a fence has been damaged. Yeah.
Yes.
Well, Neil, let us know how that one goes. That's intriguing. What kind of tree is it, Neil?
It's a huge eucalypt. I think it's a peppermint it's called, but it's 27-odd metres and it's long, and it's a metre at the diameter at the base.
Wow. Okay. Yes.
What did it do to the...
But let's be honest, Neil. How long are you going to leave it there to dry out properly?
Well, we have to get it removed because where it is sort of very problematic for us. has also gone through rotundas and glass houses and everything.
Oh,
Oh, wow.
It's a very
Okay.
significant issue. And we also had to get the fencing tempered or repaired properly because we had dogs.
I
that's
can
really-
also say that if it was a 27-metre tree, it would not be just affecting me, it would be affecting the person on the other side as well.
Neil, I
It
think
doesn't quite reach it. We're on an acre property, so
Okay.
it's almost taking out the other fence.
you've buried the lead about who can use the timber. The point here is a big tree has smashed into my glass houses. How do I get the neighbour who owns the tree to sort me out?
It's a claim on your neighbour's insurance policy,
Absolutely,
Neil,
it
not
is.
yours.
Yeah, alrighty. Thanks. Nice to hear from you. Ashley in Berwick. What's going on, Ashley?
Hi, David. Hi, Virginia. We were guarantors for a couple of our children, and on a home. They've refinanced, and the bank with another bank. But the bank that we were with have retained electronic control of the certificate of title.
No, they haven't, Ashley. If the original borrower has refinanced with another bank, then the other bank now has control of the title.
But they haven't. We're not guarantors.
No, I understand that.
Other
So there's what you would call a loan agreement, and then which is the borrowing document, and then there's the grant of security. You're not a party to the granting of security because that's the mortgage, but you'll have for a period of time a residual liability as guarantor, maybe for a year or two. There's nothing outstanding. What the bank is doing is making sure that in the event that somebody comes back and says, I want to set aside the discharge of loan, if there was a fraud involved, then the bank wants to still be able to have a go at you for a period of time, but they will ultimately release you from the guarantee.
Yeah, they've registered the discharge of mortgage.
Yes.
And I've got a copy of the electronic printout from their SERB.
Yep.
But they're just saying they've retained electronic control. So that would go on for another...
Ashley, that makes no sense. The title, they will have registered a mortgage over the title. When there was a refinancing went through, that mortgage would have been discharged and a new mortgage taken. Right now,
yes, that wasn't, but it wasn't. It was only against the home that the current home that the
okay. So you've
daughter's
given a
living in.
mortgage to support your guarantee, have you?
Yes.
Okay, rightio. Well, in a period of time, what you want to do is ask them when they will discharge your mortgage supporting your guarantee.
They have said they have discharged that. They've already registered the discharge of the mortgage. They've simply
Over your
retained the
property.
electronic control.
Oh, okay.
Yes,
Then you
over.
tell them that you want a paper title, and they will give you the paper title.
Right.
So you go back to them and say, I want a paper title, because the banks don't like hanging on to electronic documents for people who aren't banking with them. So you tell them that you want the title released, and they will arrange for a paper title to be issued and sent to you.
All right. I hope that's clear. Good luck, Ashley. Bob in North Melbourne. Hello, Bob.
Good morning, Virginia. Good morning, David. Love your program. Fantastic.
Thank you.
Look, just I've got a bit of a crappy question. We share a sewer connection point with two other houses.
Yes.
Any blockage, we need to access that point to clear things out. Anyway, last week we were all blocked up. I knew where the point was in our neighbour's property, and contacted them, and then contacted a plumber. What I didn't know was that the new owner of the property, our next door neighbour, had the point relocated when they had a renovation done a few years ago.
Yes.
As a result, the plumber spent 7 hours plus fruitless calls to water authorities to try and find the location, and in the end had to get an excavator in to dig up the whole front yard. So, what would have been a 2-hour job ended up being a 7-hour job.
I might get you to the question if I can, Bob.
Okay. The question is, who is responsible for this big bill? Is it the three house owners, the owner who moved the inspection point, or the builder who moved the inspection point without notifying the authority?
The plumber, there would have been an obligation to notify the authority when you moved the inspection point, because there was plumbing works on site that should have been notified to North Melbourne. So City West Water, Greater Western Water should have been notified.
No, well, they weren't, no.
Right, and then I would be having a go at the plumber for moving it.
Okay.
But if you were to look at a shared sewer point, you need to look at, because there'll be lengths of the pipe that are different people's responsibility.
Yes.
Yep. But I would be having a go at the plumber for moving the inspection point without notifying the water company.
Bob, I hope that's helpful, and good luck with having that particular argument. Jan in Barwon Heads, good morning, go ahead.
Oh, hi. It's about the fence.
Yes.
And our neighbours aren't keen to put in a new fence. So I believe I've obtained the 3 quotes and via the council website, given them the letter, and they've said no. So my next option, I believe, is the Magistrates Court, and I'm just concerned I might be incurring lots of extra costs by doing that.
You probably will be. So in the event that you don't get a negotiated outcome for the fence, you might try Dispute Resolution Victoria and see if they will conduct a mediation for you to assist you, and that failed too, didn't it? Then it is off to the Magistrates Court, and if you go to the Magistrates Court, you will get a contribution to the costs that you incur. But the other thing you need to know is that you can't do any fencing without a Magistrates Court order or the consent of your neighbour. So what you might consider doing is negotiating with your neighbour as to the costs. So you might be able to pay, come along and say, well, I'll pay an extra $500 rather than run the risk of going off to a Magistrates Court.
Now, I spoke to the Magistrates Court and they said it's about $350, I think, to lodge, and they said that would be all that I'd be required to pay. Is that correct?
Yes, that's correct if you act for yourself, yes.
Right.
So you can act for yourself, and you have a look at the Fences Act, and there's a guide in the law handbook, so the lawhandbook.net.au, which will tell you what you need to do and how you might do it.
Okay, thank you.
Thank you.
What's the objection of the neighbour to getting a new fence?
Who knows?
Does the fence need to be replaced?
Yes, it's 30 years old. It's falling down.
Right.
Who knows?
And it can't be repaired, is that right?
We've spent significant amounts repairing it, but it's beyond repair.
Okay, then that's the process. Magistrates Court, if you act for yourself, then you won't incur any costs unless you lose and they have a lawyer acting for them, in which case you'll be paying some costs.
Oh, fences.
My recommendation, Jan, is that you pay for a lawyer's time for a couple of hours to walk you through the process and the presentation of your evidence. All right? Now, you won't get those costs because they're not acting for you in the proceeding, but you improve your prospects of the outcome.
We had a similar problem. It's a commercial site next door, and so getting any agreement or putting a fence up was a nightmare. So we just funded it ourselves, but just put it in 1 centimetre within our boundary, so then we didn't have to deal with next door because we were doing it entirely.
It's not a boundary
on our own.
fence.
Yeah, that's right.
Yep.
Exactly. So there's that. If you're prepared to, give up a centimetre, which is, neither here nor there when it comes to actually sleeping quietly at night.
Indeed.
Great to see you, David. We'll see you
you.
next week. Thank you.